So welcome to this discussion, intellectual property law. So basically, as far as this week is concerned, we shall be looking at intellectual property. So most of you who did not do intellectual property at your undergraduate, please don't get scared. The principles are very simple and straightforward. Just pay attention as we burst that bubble, but don't get scared. Once you listen to this video up to the very end, then you will be an expert as far as intellectual property is concerned. So please like, subscribe, share, and comment so as your friends can benefit from this video. But also have to be aware of the fact that they always ask about intellectual property law in oral questions. So that's why it's very, very important that you watch this video up to the end of it, because I will be giving you tips on basically how to answer questions as far as this part is concerned. So, and in this module, we are introducing students to various aspects of intellectual property registration, and the rights that accrue from such registration. So basically, when we talk about intellectual property, it basically means the creatures of a human mind. That's what we basically mean intellectual property. I remember when we were at undergraduate and we are dating. By that time, we used to tell girls that however much I don't have a car, but I have intellectual property, so I can buy a car anytime. So basically, when we talk about intellectual property, we mean the creation of a human mind. So if you can author a book, if you can produce some music, all that is under what we call intellectual property. So we shall look at also intellectual property registration, that for intellectual property to be protected under the trademarks law and copyrights, they must have been registered. The rights that accrue from such registration. So once you have registered your work, then that means that you have the right to be accredited to that work. Once it's being used or it's being referred, you have rights to distribute it. You also have rights to authorize other people to use that work. So basically, when you talk about intellectual property, that's what we basically mean. So intellectual property is a category of property that includes intangible creations of the human mind or intellect. There are many forms of intellectual property, but in this module we shall handle trademarks, copyright, and neighboring rights, image rights, and industrial designs. So basically, when we talk about trademarks, these are defined under Section 1 of the Trademarks Act to include signs or marks that distinguish products or services of one manufacturer to another. So that's what basically we call a trademark. So when you talk about Benz, when you see a logo of Benz, you definitely identify it. When you talk about BMW, when you see a model when you see a logo of BMW, you identify it. Toyota, it also has its own logo. But also we have things like Adidas, which has 3 white strips lines. Those are all what we call trademarks, because trademark is a sign or a mark that distinguishes products or services of one manufacturer to the other. Then also look at copyright. So what is copyright? If you have authored a book, then you have copyright about that book. So basically, copyright is materials which have been reduced into writing or maybe in a recorded form. So like this now, this YouTube video I'm recording, you could author a book, you could author an article. All those ones fall under what we call copyright. Then we shall also see at neighboring rights. So neighboring rights basically accrue from third parties. For example, if you have authored a book and I have come in as a distributor, I have what we call neighboring rights. I'm not necessarily the author of that work, but because of what I'm doing, I have acquired neighboring rights on your book. So it could be like, for example, I'm giving an example of English Premier League. DSTV has neighboring rights to broadcast it in Africa. So those third parties who come in to either distribute, broadcast, perform, who are not the original authors of the work, we refer to them as neighboring rights. So image rights, there have been a lot of contentions where MTN comes up and uses your photo when you are not known. I think even at one point there was a student who wanted to LDC that they were using his or her photo when he hadn't given them permission. But those things always arise, and when that happens, under Article 27 of the Constitution, we are guaranteed a right to privacy. So you are not supposed to use someone's image when you have not gotten you don't have permission from that person. That's why you find that all the students I always put on this YouTube channel, I first have seek permission from them. But I can't just get your photo because you are smart in your mood and I just upload it on my YouTube channel. So basically you would sue me for violating a right of privacy, and you'll be entitled to damages. So all the students you always see on this channel, just to know, they have given me consent to put their photos on the YouTube channel, and they have the liberty to withdraw that consent at any time. They say, Ramsey, for mine, no longer want my photo on your YouTube channel, because remember, this channel is accessed globally. So students around the globe and other people who are interested in the law are still viewing those images. So that's what we call image rights. So when we talk about industrial designs, you have seen, for example, Gwenzori, how that bottle is designed. We have seen Coca-Cola, how that bottle is designed. So basically that's what we call an industrial design. So even though industrial design is also protected if it has been registered. So the law gives persons rights to certain intellectual property that they create. The law allows the person to protect original ideas and prevent unauthorized exploitation of the same. Creators are given greater economic benefit from the information and intellectual property they create, which is an incentive to create. These intellectual property rights form the foundation of doing business worldwide. It's therefore imperative that legal practitioners are equipped with skills to advise clients on intellectual property rights. So basically, intellectual property law is very, very important in business, first and foremost in branding as well as in marketing, because if there was no intellectual property law, I would also go and produce my own Benz and put the logo, and clients would find it hard to distinguish what is really fake and what is genuine. So that's why intellectual property is very, very important. So workshop 1 aims of this workshop is to develop ability to advise on trademarks. Like they have said, that trademarks are under the Trademarks Act. Then we shall basically be looking at what is a trademark, how do you register a trademark, and how do you protect it. We shall look at the developability of trademarks rights, how do you protect trademark in case someone wants to use your trademark. Then we shall look at ISCO issues. So learning outcomes, identify various forms of trademarks and industrial designs and their legal implications. So illustrate the procedure of registration of the trademark. So we shall see how basically you go through registration of the trademark, illustrate the manner in which trademarks rights can be protected, draft documents related to registration of trademarks, and recognize and deal with ISCO issues. So we shall bring part A, we shall bring a Coca-Cola bottle, Pepsi, Reham, plastic Reham, Fanta, Phantom, a plastic Reham, and empty Guinness, a tin or container, Colgate or toothpaste. So identify the various intellectual properties on or constituted by the items above with reference to explain why they are considered to be intellectual property. So basically, in dealing with this, we shall be looking at trademarks as far as the Coca-Cola bottle is concerned. Section 1 defines the trademark as a combination or signs or marks capable of distinguishing products of different manufacturers. First and foremost, when you look at the Coca-Cola bottle, you find that the shape of the bottle itself is what we call industrial design. So under section 7 of the Industrial Property Act, the shape of the bottle is protected. We shall see also all those signs on the bottle, how they are shaped, because all that now is protections under trademark if it has been registered. Then we have that arrow you see on top. That arrow means it's been registered, whereas the TM means it is not yet registered. So when you see an arrow on top, that Gwenzori is there, it basically means that it is a registered trademark. And where there is a TM, it basically means that it has not been registered. It has not been registered. So basically that's it, how we shall be going through these different products. Just look at the industrial design, the marks and designs, and at the end of the day, all those utensils shall be protected under the trademarks law if they have been registered. So then from there, we shall proceed to look at basically in the case of trademarks, identify the parts of the trademarks register and class under which each one of them would be registered. So basically we have basically two classes, that is class part A and part B. So part B, basically part A of the trademarks, we look at section 9 and section 10 of the Trademarks Act. It basically provides for these parts, part A and part B. And we look at part A, Part A, they register classes which are distinctive trademarks. So those ones which are distinctive are registered in Part A under Section 9 of the Trademarks Act. But then under Part B, we always register those ones which are not distinctive in nature. So that's why we register Part B. But when you look at Section 9 and Section 10 of the Trademarks Act, they basically give you circumstances under which you will register products under Part A as well as Part B. So Part A basically deals with those products which are capable of distinguishing other from other products. So we looked at identifying any similarities in some of the marks in some classes above that could have influenced your decisions as registered trademarks permit or decline registration of the said mark. So basically, here, once a register has been, once the person applies to you that he wants to register a product, you have to see whether it's resembling another product, or maybe there is a likelihood of confusion. There's a likelihood of confusion if there is a similarity, and also you're going to mislead the other person's customers. So basically, you're supposed to always object. So basically, how we shall be looking at maybe if there are any similarities that might lead to confusion in the market. So D, prepare a brief press release of not more than 100 words announcing a 2-year sponsorship of a football tournament by Coca-Cola and Nevia. The tournament will be the National Football Corporate League of Uganda, which is duly licensed by FIFA. Please note that Coca-Cola is manufactured by Century Bottling Company and the license from the Coca-Cola Company. Ensure that in your communication, you communicate the adequate protection for the different marks. Why is it necessary to communicate in the manner you have? So basically here, when you're, of course, going to be communicating this, you have to be alive to the trademarks law, and also who are going to be the broadcasters, and also Coca-Cola, whether they have been authorized to become the partners. You understand? So basically, we shall be looking at all those things in this our presentation. But the focus is once you have a national football league, which is duly licensed by FIFA, and Coca-Cola is going to be partnering with them, then we shall all be putting that in our presentation in light of the Trademarks Act, as well as the Copyrights and Enabling Rights law. So Part B, we have Mieba Industries Limited. Mieba Industries Limited is a company registered in Uganda which deals in the manufacture of various bottled alcoholic drinks. The company has been in exclusive and trading since 2017. It has since branched off into the alcoholic beverage industry, targeting local traditional drinks made in Uganda. The company has started off its local alcoholic beverage product line with a drink called Enture Spider Extra Mark. So Tasks 1, advise the director of ML Company Limited on how the company can protect its brand name to prevent it from being used by other manufacturers. So basically here, how it can protect its brand name, it basically means that we have to proceed and do what we call registration. We have to proceed and do registration, and this one is under Section 5 of the Trademarks Act. You have to apply to the registrar. The registrar now conducts a search to see whether there is any other persons using that trademark. Then after that, you proceed. If there is none, you apply in a prescribed form. Then after the application is gazetted under Section 11. Then after that, after the gazettation, if there is no objection, they issue a certificate of registration. So basically, they shall be doing at the process of registration of trademark. The necessary documents we shall be looking at. One, we have a request for search of the registrar, an application form. So basically, here we shall be looking at the request for search of the registrar, as well as an application form. Those are documents we shall be drafting as far as this thing is concerned. So we shall draft an application form as well as we have a search letter to see whether this trademark is available. Then we shall do an application form. Then from there we shall do a search letter and application form. Those will be the documents. Then issue 3 wants us to assume you are the registrar of trademarks and you've been presented with the documents in 2 above, and take the necessary steps to handle the registration. So once as a registrar have been given this search, the first thing you have to do is of course conduct a search and see whether there is any other person that is using the same trademark. And then after that, you have to gazette. After gazetting, and if there is no objection, you have to proceed and publish in the Gazette. Then if there is no objection, you have to issue a certificate of what? Of registration. You have to issue a certificate of registration, and basically that's how you have to be going about that. You have to conduct a search to verify whether there are any other users. Then after that, you have to issue what we call a notice in the Gazette. Then if there is no objection, you have to continue and give a certificate of what? Of registration. So part D, we are dealing with Super Concrete Limited as a private limited liability company which deals in the manufacture of a compound called same seal, which is added to cement to give it more water resistance properties when used in wet areas during construction. It also reduces the amount of cement required in construction of kitchens, bathrooms, and exposed concrete slabs. It has become so popular that so far the company has sold over 200 million bags. Task 2, advise the director on what he can do to protect the company's registered trademark, and also draft relevant documents. So basically here you see Super Concrete Limited is a private limited which deals in the manufacture of compound called steam seal, which is registered, which is added cement to give. Then we see it is sold in 5 programs. Recently, the director of Super Concrete an advert. So basically, here you saw someone in the advert who wanted to use his product. But I think I have jumped part C. Let us first go to part C. Assume that in A above, the company's trademark application was rejected in ground that is similar to Spider Dick of HDL. ML has been selling into the Spider since 2022. Advise on whether and how the wishes of the director can be affected. So basically here we shall look at what we call concurrent use under section 27. Concurrent use is where the registrar or court allows the registration of the trademark for more than 2 users. And this one will arise in cases of where there is honest concurrent use or any other special circumstances. And we have the case of Nairobi Java House versus Mandela Auto Spares, where Justice Mandrama emphasized that their parents' long-standing use of the mark in Kenya had acquired distinctive and ruled that the two were capable of concurrent use. So basically, concurrent use arises where you find that you have been using a trademark for a long period of time. So you are not trying to get a free ride on the other person's brand and market. So where the court or the registrar in his view thinks that it's a honest use, he can proceed to do what we call concurrent use. So this concurrent use is under section 27, and the necessary documents would be a notice of motion supported by an affidavit if you're going to court. So assume further that MIL and HDL had gone to court to fight the battle. However, with your guidance on importance of ADL, they have realized they can each serve different segments of the market with their respective drinks without getting into each other's way drafted. Relevant clauses would include in the consent judgment of consideration by board of directors of both companies. Use the facts in part B and C for this task. So basically here we have to draft what we call a consent judgment, and we see which clauses would we put inside there. So you know that consent judgment basically happens where a person now agrees outside court and then proceeds to give this court a judgment. So basically we're going to draft in form of a consent judgment, basically in light of those clauses. So A, we see it's a concurrent use. So part D, we are looking at how basically if someone wants to take our logo, advise the director of Super Concrete. So basically if someone wants to take over your logo, what you have to do is you have to proceed and lodge an objection, because that's why we have what we call that notice in the Gazette. So you have to object under section 12. A person can file a notice of objection. Procedure for filing objection under section 28. It's in a prescribed form, and once you must state the grounds for objection, which can include the likelihood of confusion, and then you must attach the declaration supporting your grounds, and you file a notice of objection to the registrar supported by certain declaration. So the documents here we shall be drafting will be necessary documents. We have the form of objection, which is in a prescribed form, as well as certain declaration to object to the registration of that trademark. So basically that's what we shall be doing there. Assuming accounts for the Trademarks, advise your client and undertake necessary steps to protect its interest. So that's how we are going to be looking at what he can do to protect the company's registrar, draft the relevant documents to effect your advice. So basically, you have to proceed and object. Once you have objected, you draft the notice of objection supported by self-declaration. Then for build marks, it has also now also, because it has to reply and enter what we call a counter statement. So basically, if your thing has been rejected too, then you have to proceed and enter a counter statement, basically about you file a counter statement under Section 30, also filing supporting evidence, which includes also a stated declaration. So use by the applicant to file a counter statement and stated declaration. So basically, the documents here we have is a counter statement supported by stated declaration. So when we go to part E, assume that Super Concrete Limited and Buildmarks Limited had a successful mediation which you handled using the ADR skills you learned while still a student at LDC. They have agreed to trade mutually and as cooperate with each other. Super Concrete Limited will continue to make products limited to cement advertises for purposes of creating waterproof concrete structure, while Buildmarks will limit on its operations to manufacture silent of cement wear. So advise Super Concrete and build on how they can both have their marks protected by registration. So basically here we shall be looking at what we call permitted use, or we shall be looking at what we call permitted use, and this permitted use is provided for under section 49 of the Trademarks Act. Permitted use is where the students or the parties agree to proceed and do what, and use the same trademarks together. So the necessary documents we shall be having how they can use each other's marks with permission, permitted use. So advice on how they can both have their marks protected by registration. So we are going for permitted use basically. So here, first in part A, they can consider one the registration, but two also they can go for concurrent use. Then two, how they can use other marks with permission is the permitted use. And necessary documents in permitted use, we should basically have a permitted use agreement or mutual license agreement, as well as the documents applying for what we call permitted use, which is basically in a prescribed form supported by a stated declaration. In a prescribed form supported by a stated declaration, as well as a mutual licensing agreement. So basically, that's how we are going through workshop 1, and that's basically what we shall be looking at. But in case you didn't do intellectual property, and you feel like you need some more push, remember we have a discussions online which covers all of the 4 campuses, Mbari, Mbarara, Kampala, and Lira. So basically, in case you want to be part of that group where I can give you an extra push, repetition is the mother of all skills. You have to repeat these things until they stick into your head. So you need really repetition. You can come to this discussion, going to our discussion, going to the PA's discussion. That's how things will naturally stick. It comes out of hard work and repetition. But in case you want to to join our mastermind group for our mentorship, we charge a monthly subscription, which is at an affordable price. You can inbox me on the number on my profile. Then if you can afford that budget, if your budget allows you that, then you can be in position to guide you further and also give you adequate notes. You don't need to suffer with making notes, just give you adequate notes. So basically, that was it for workshop 1. Let us proceed to workshop 2. So as far as workshop 2 is concerned, the aim of these workshops are to develop the ability to advise on copyright and neighboring rights. So whereas we are dealing with Trademarks Act in workshop 1, here in workshop 2 we are dealing with Copyright and Neighboring Rights Act. Develop the ability to establish the existence of copyright and neighboring rights. Develop the ability to advise on the protection of copyright and neighboring rights. Learning outcomes. Develop the ability to identify copyright and neighboring rights, and develop advise on copyright and neighboring rights. Develop the ability to protect copyright and neighboring rights. Develop the ability to draft contracts and recognize and deal with ESCO issues. So part A, any volunteer from class should sing a folk song in their native language and explain to class what it means. So folk songs are those songs which we used to sing from in our tribes. So basically, anyone would volunteer and sing. So, but the task we're going to deal with in task 1, assume that the clan leaders of the tribe where the folk song is adopted has asked your raw farm to protect the folk song so as prevented from ever being used by another person, tribe, or client without permission. Will you be able to protect it? Give reasons for your answer. So, what you have to understand under Section 3 of the Copyrights and Neighborings Act, for the works to be protected, they must be in a written form or maybe recorded form. So, and they must be in its original form. So, if this work can be reduced into writing or maybe recorded form, and they can prove its originality, then we can proceed and register it. We can proceed and register it. Then, 2, assuming a Ugandan musician been in Uganda, one Badman Rasta attended the clan ceremony and had a folk song in one above. As he was driving home, he started playing it out loud and stammering instruments for the song. His manager was next to him as hammered along. The manager thinks the song would be a club banger. Advised the Badman Rasta boy and his manager on whether they can make their hit banger and protect it under the law. So basically here we are dealing with derivative work. When you look at basically Section 4 of the Copyrights Act, they provide what we call derivative work. So it basically means that you can be able to make a music from that song and you proceed and register it under Section 4 of what we call derivative work, and can be registered. Derivative work is just work you have got or made out of some other work, but with the consent of the original authors of that work. So, why they would have to do so to enjoy their full rights to their composition, we have to proceed now and do what we call registration. Registration of this derivative folk song. So the process of registration, basically, you have to proceed under Section 42(1) of the Copyrights Act to apply for registration, and then after that, it's through an application form. Then they publish it in the Gazette, and then after that, if there's no objection, they proceed to register it, and now you have what we call copyrights over that work. And we have the case of Uganda Performers Rights Society versus Fred Mukubira, where the court stated that for copyright protection, a work must meet requirements such as originality, material form, and independent effort. So basically, the work must be originality in material form, and it must be your own work. You must have put in independent effort. So where they can stop another person from making a hit out of the folk song with variations to their composition. So basically, it basically means that if someone can still make another song from the folk song if you got permission from the authors, but he cannot use your own composition. But you can't stop, because for you register the derivative work, not the folk song. So basically, that's how you have to be dealing with that. Then task 3, assuming Bad Boy's man friend Jose Rukambo, a Congolese musician based in Congo, he had the ideas Badman was exchanging, and then proceeded to act fast. He put in so many hours of work, and after 1 week he was in Showbiz Avenue, and then he produced the work. So they're asking us, Badman Rasta Boy and his manager are incensed and are threatening legal action. Do they have a valid claim? So basically here, first and foremost, the question now becomes whether these people had already registered their work, because you see the conversion took place in the car. Under Section 5, ideas, concepts, procedures, and methods are not protected under copyright law. So where you sit on your rights and you don't act faster, and someone acts faster, puts in effort and registers, then that means you have nothing to protect. And you can see under Alhaji Nasa versus MTN Uganda Limited, Justice Smart Drama ruled that the mere ideas are not protected under copyright law, but the work must be reduced to material form to qualify for protection. So the author must demonstrate that substantial effort was expended in creating the work for it to be eligible for copyright protection. So if these guys had not registered, then they have no protection under the law. So part B, bring the following items to class: an original music CD, a novel, an its original form, a textbook, a newspaper, and a painting with information. So basically here, they want us to with reference relevant to identify all copyright owners in works you have brought. So for copyrights, we have first and foremost music composition in the music CD, music compositions. Under section 4, we have composers, lyrics, sound recordings. Under section 4, we have producers, artwork and CD cover, graphic designers. Under section 4.1 of the Enabling and Copyrights Act. The novels, we have authors. Section 1 of the Copyrights Act. We have cover designers. We have publisher layouts, newspapers. We have articles by journalists. We have photographs, editorial content, as well as advertisement. So basically, those are some of the people we shall be looking at. Identify all the neighboring rights in the materials you have brought and whom those rights accrue. The neighboring rights we shall be looking at performing rights under section 21 of Copyrights and Neighboring Rights Act. So performing rights, basically we have, for example, you find in situations we have writers and performers. So where I write a song and Shiba performs it, it basically means that Shiba is the performing artist. So she basically has neighboring rights. So we shall be looking at performing rights, producers' rights, as well as broadcasting rights, which fall under what we call neighboring rights. So from there, we are proceeding to assuming that Jesro, a profile painter operating an art studio in Buganda Road, wants to make replica copies of one of the paintings in E above. Advise him on how to go about it. So basically, that means he has to get permission from these very people, because you cannot proceed to work on this when you have not gotten permission from these people. So this is the only way we can do this after getting permission from these ones. Then for assuming that MC Silva, a popular musician in Uganda, would like to redo the music compositions on the original music CD you brought, is going to use the same beats to the composition but spice up the music with a wrap up in English. Advise MC Silva and Bram on the authorization they would need to have. So basically here, the authorizations under section 8 of the Copyrights and Neighboring Act provides that owner of the protected work shall have, in relation to that work, the exclusive rights to do or authorize other person to reproduce that work. Section 9 provides for moral rights for object and seek relief in connection with any distortion, alteration, or modification. So basically, you cannot use someone's work without authorization. So they have to proceed and get deliver permission from these people under section 8 of the Copyrights Act, because remember, you cannot do anything without those rights. What form will the authorization take? We can see it would be licensing agreement, which they will have to draft. So for further learning purposes, by over illustration for part B, task 4A and B above, here below are links to 2 songs using an internet connection. Listen to them carefully. Read these songs, task in fee A and B. Pay special attention to the information relating to the 2 songs as available on the internet. What authorization do you think we obtained to perform the latter song? Explain why. But basically, when you're going to go for a song, you have to get permission from the original author. You have to get permission from the original author, but I haven't listened to the songs to be in position to advise appropriately. So D, assuming one of the authors of the work that MC Silva is going to redo was one who died, the song question is, what a wonderful world, what necessary information would you take? So basically, under copyright law, section 8, your work is always protected after 50 years after your death and also during your lifetime. So your work is always protected under section 8 for up to your lifetime, and then after you have died for 50 years. So if this person have died for a long time ago in 1971, it basically means that the copyright on his work would have expired in 2021, such the song would now be in public domain and no permission is needed to use the composition in Uganda. But however, under section 9, you have to attribute that song and also make sure that its integrity, you don't misuse, and because that will affect his own moral rights. So you have to make sure that you have made attributions as well as integrity. So part C, Ugandan artisan queen Karma is organizing a mega performing under Bram production. She has received a notice of invitation to sue from Agropa, who have written and produced most of her songs. She has been warned against singing any of the songs without written permission from Agropa. Also want a cut from the proceeds of the show before they can allow Shwara to sing the songs. Bram are desirous of recording the performance and selling CDs to show. Advise Shwara on whether they can do this. So basically here we shall be looking at section 2, and also is a physical person who creates work eligible for copyright. Under section 21 we have rights of performers, including a fixation for his or her live performance, broadcasting or communication in the public domain, direct or indirect production of a fixation and distribution or making available the public of the original or copies. Then whether Bram production can sell recordings, we shall be looking at first and foremost section 27, rights of the producer, because you remember this one is a producer, whereas the other one is not. So section 27, rights of the producer include producer of sound recording, audio visual. Producer of a person shall have the right to authorize making, fixation, and no person shall produce or dispute or make available work. So basically that's some of the things we shall be looking at under the rights of producers. Remember, a producer is when you go to music, we have and also the work who basically creates the music, we have the producer of the music, we have also the performer, and all those persons are protected under the Copyrights and Neighboring Act. When you look at section 27, they provide for rights of the producer. When you look at section 21, they provide rights of the performer. So it basically means that those people must be enjoying those rights. So now the Bram production is now a producer in this instance. So part D, we are looking at musician Eddie Kenzo, who has become so popular across many countries, including England. Is upset that people are copying his music illegally and selling it to Ugandans living in London and making so much money. So first and foremost, we can see there is infringement of his rights. So basically, advise, he wants to stop. How can he do this? If so, how? So first and foremost, we have the collective societies under section 56 and 57. We have the collective societies. These are societies which are always joined by musicians, and their role includes promote and carry out public awareness on copyright, to make reciprocal arrangements, help members in preparation of standard forms, and to foster harmony and understanding between members, and provide its members with information. So we have the case of Uganda Performing Rights Society versus MTN, where the court said that the society had locus to bring a suit as a plaintiff without joining the authors as the plaintiff. It basically means that these societies can help this person sue and also collect all these things without him going there. So how can he how can he partner with Apple Inc? So how he can partner with Apple Inc? We can see first and foremost, he can have what we call having a licensing agreement, and he must have a licensing agreement. The potential holders of rights, we shall see producers, we shall see performing artists, we shall see those ones who made the work, the authors or the authors of the lyrics, who have also rights under his work, because Eddie Kenzo doesn't only do the work himself. He has those people who write, he has writers, he has people who producers, he had broadcasters, he has distributors. All those people have to be contacted. The remedies available to him under these circumstances, whereby his rights are being violated, he can go for what we call injunction, damages, as well as Antonio Pira order under section 44 of copyrights and neighboring rights, or what we call search and seizure orders. Then part E, Uganda Broadcasting has just learned with excitement that through March Choice has run a contract to broadcast the English Premier League in Uganda. March Choice has decided to stop broadcasting the EPL in Uganda. However, March Choice will continue to broadcast the English Premier League. So carry out personal research, establish who owns rights to permit broadcasting of the English Premier League. So basically, we can see that the English Premier League is being owned by DSTV in Uganda, basically in sub-Saharan EPL is being owned rights by the what? By the EPL. So basically, if you want to broadcast, it basically means that you have to get permission from EPL. So of course, Section 1 defines broadcasting company to mean a company which communicates or carries on transmission or broadcast programs. Section 1 neighboring rights include rights of performing artists. We have the case of Anthony General versus Sanyo Television. Formed Sanyo Television live for broadcasting World Cup matches, as Ghana Broadcasting Corporation had exclusive broadcasting rights. So whether UBC can obtain rights to revise the EPL in Uganda, of course through a license, they have to negotiate directly with the Premier League and then sub-license to March Choice and acquire non-exclusive rights. And the documents here we are drafting is a licensing agreement. So now here we have assume further that the Radio Budo has obtained the necessary authorization. They have identified a very handsome man really in Simbi Mukasa. So basically, for you to use his photo, you have to contact him, because under Article 27, remember, we have protection to right privacy. So you cannot proceed and use someone's photo when you have not gotten permission from this person, because it will be a violation of his rights. We have very many cases. Asangewini versus Opportunity Bank. The court adopted the common law definition of personal rights as an individual right to control the commercial use of their name, image, or any other clear aspect of their identity. So you cannot just go and use someone's name without his or her consent. Task 3, your professional advisor would like to be advised on the following. A, you would like to make copies of all marks in workshop 1 which you brought to class, so that each student can have a mark on their hands during class. So basically here, for education use, we can see that under section 14 of the Copyrights Act, we have exceptions to copyright include private personal use and also education use, or maybe fair use. So where you are doing work for education purposes under section 14, it becomes an exception to infringement of the copyright. So B has been permitted by the Head of Subject to make copies of those workshops, be able to use them in lecture students at a new university in Kashinat University. So basically there we are going to see that this is basically for commercial purposes. So under section 1 and also includes the employer, so which basically means that this person cannot proceed to use this work without consent from LDC. So the head of subject is not your employer. And section 1 defines an author to include an employer, which basically means LDC is the employer of the PA, and the PA has to get permission from LDC. So basically that was it from us. I believe that I have given you an analysis and compression of intellectual property. That's basically what we shall be doing with next week. Very simple and straightforward principles, very well covered by the Trademarks and Copyright and Neighboring Act. It's very conclusive. I've read the act. Most of these things are going to be answered. So please don't fear. Go and read your acts. All these things are there in the acts, and you'll be fine to go. But in case you want some extra push, please join us in our mastermind group. We run a mastermind group. Students pay 100,000 per month, and we provide notes, discussions. We guide you on your mode. We also help you prepare for orals. So it's a very big community with students from all campuses, Mbarara, Lila, Kampala, as well as Mbari. So you get to hear what the feedback from different students, what their PA is advising them. So please like, subscribe, share, and comment, and always come back. Even turn on that notification button so as you don't miss any update, because we started the course with you and we're going to finish it with you. Please have a blessed week. We wish you success in your IA from the Pass the Bar team.